For those of you that don't know me, my name's Andrew Hartley. I'm one of the senior attorneys here at Wilson Gunn. I work on the patent side of things, so my role is going into companies, typically clients, and many of which are here today, and interact with them and look to protect their inventions through patents. We thought we'd do another talk today. We did one a couple of months ago on patent searching, so thank you if you attended that one. If you're interested in patent searching and couldn't make that one, do let us know. We've got a recording of that one as well. Today's talk is about how to create a healthy IP environment. So this is a sort of reflection of our experiences working with a large range of clients, both UK and international, of all different sizes, across all different types of technology. And the things that we see that go on within these companies and messages that we put out there from time to time in terms of how that they can create a healthier IP space. To put that in context, I'll skip on to the next slide, he says. Okay, so hopefully most of you will be familiar with the basic intellectual property rights, so patents which protect technology, trademarks which protect the brand and the goodwill, the brand value of a business, designs which protect the aesthetic appearance of an article or product, copyright, which tends to be more for aesthetic creations, and then last but not least, know-how and confidential information. So within a business, you will of course have your processes in place, your ways of extracting inventions, for example, out of a business, and then turning those into patent applications and getting those through to grant, obviously with our assistance, the same with trademarks and designs. That's obviously one side of processes, and part of what goes on inside your business in terms of creating a healthy IP environment will be about that side of things and the registered rights and getting those through to grant, and getting the protection in place. The talk today is actually more about the know-how and the confidential information. So when you think about a technology business, which this talk is predominantly based around, the actual intrinsic value of the company is probably more in, or almost definitely within that confidential information, with that know-how. The value of a technology company is partly tangible assets, so physical things like buildings and inventory, cash, that sort of thing, and then also intangible assets. So those would typically be for a technology business, and the majority of the intangible assets would be the goodwill, so the relationship that you have with your customers, your clients, and also the technology which underpins that goodwill. And it's the manifestation of that technology which we're interested in today, and where that exists within a business, and how you can look after that information, that know-how, so that you keep control of it, and make sure that you can use it to your own ends. So as part of that today, we're going to be looking at what is intellectual property? Where does that exist within a business? How does it manifest itself? And then also just look at some processes that we can introduce within a business, so internal processes, so that we can see how to handle IP within the business, how we can handle that IP external to the business. And then also to have a quick look at what we do with IP which comes in from a third party. So most businesses dealing with technology will at some point receive IP, either knowingly or unwittingly, from other businesses, and there could be obligations for you to deal with that properly. So we're going to take a quick look at that. With regards to the more sort of registered rights, the patents, trademarks, designs, and processes for getting those registered, we're going to look at those in a separate talk, which hopefully will be in a couple of months, so similar sort of format, and we'll be giving you some sort of tips and tricks for implementing sensible ways to sort of review when to file, how to get inventions out of a business, for example, with regards to patents, how to assess business case and importance, filing strategies, that sort of thing. But I say that will be part of another talk. It's a subject in its own right. So in terms of confidential information and know-how, there is a preliminary question of what is IP, how does it manifest itself in a business, and then how should you handle it once you found it and defined it. So as I said, in a technology business, normally the intangible assets are either the technology themselves or the goodwill. So on the left-hand side of the screen there, we can see we've got a whole list of different stuff that would surround you in a business that your engineers or whoever it might be will be handling on a day-to-day basis. So I won't read through the list, but you can see there's data, technical reports, processes, what goes into those. It could be databases, algorithms, software, you name it. There's lots of documentation and whatever it might be that surrounds you, which describes and holds the information with regard to the technology that you produce or the processes or whatever it might be that you're supplying to your customers and your clients. So that's the manifestation of IP, and what's in those documents is the intellectual property, and it is the value that the value of the intangible assets. So if you have ever been involved with acquiring technology or a business or divesting in technology, normally it's the stuff that's within these different types of intellectual property, these manifestations, which is the thing of value. It's the thing of interest. It's not necessarily and often isn't the patents. It's the thing that allows you to operate as a business and turn your knowledge into a product which generates money or a service which generates money. It's that we're interested in today, and how to preserve the value around that. With regards to goodwill, so the stuff on the left is for more technical stuff normally. The stuff on the right hand side, design, appearance, packaging, marketing and advertising, the stuff that goes to interface with the business and help reinforce the goodwill, the bond between you and the clientele, the customer base that you're enacting with. And then there's other stuff as well, so customer lists, financial information, all the other sort of ancillary stuff that's in a business which you need to operate but isn't necessarily to do with the technology or the goodwill. There's no direct connection. I suppose customer lists in itself, your customers are inherent to the goodwill, but a list of customers is an intellectual property and asset within its own right, and has its own value in its own right. So we've got a reasonable idea there on what intellectual property is and how it appears within a business, hopefully. And of course, they're not exhaustive lists. You'll know the things within your own business where things exist in whatever format they might do. So within a business, you'll have all of these things, all of these representations of information. They will all be considered to be know-how or could be defined as know-how, and it's that know-how that I say is the underpinning value of your business and the stuff that allows you to carry out your business. When we're thinking about how to protect that, you need to have some sort of control over all of these different manifestations of the information. And to have that and to do that in a practical way, it makes a lot of sense to have a tiered structure. So you will have some know-how in your business which is publicly available. It's common practice within the industry that you operate. So you could be buying something off the shelf or whatever it might be. So that type of stuff we don't really want to spend any time on protecting. If that went into the hands of your competitor, then it wouldn't really be of any detriment to your business. So we can almost put that to one side and not worry about it too much. Then we've got this confidential information, this next tier. So this is stuff that's within your business, and you'll know what it is, hopefully, within your business. Where if it did fall into the hands of a competitor, it would be detrimental to you. It might be something that you've invested time and money in developing, or spent resources in creating, and then you don't want that to go out to your competitors. If you do want it to go outside of the company, you want to do it in a controlled way, in an informed way, so that the people that own that information within your business agree to it potentially and allow it to go out in a controlled manner. Within confidential information, we've also got a subset which is trade secrets. So some people say trade secrets are confidential information, they are proprietary information, they're one and the same thing. I'm going to distinguish over them today because I do think, in terms of taking this tiered approach, it's sensible to put trade secrets to one side. I mean, the trade secrets really should be your sort of most valuable assets within in terms of intellectual property within the business, your crown jewels, the thing that distinguishes you from your competitors and or gives you a very good commercial advantage. So if it's a process, if it saves you a manufacturing process, say if it saves you loads of money in terms of manufacturing cost or time, then that could be a trade secret in its own right. Trade secrets tend to be more to do with methods, processes, just because they lend themselves very well to being kept secret within an organization. A product, for example, in contrast, as soon as you sell that and put that out into the public, that's then out there, and it can't possibly be a trade secret because it's well known. It's probably going to be reverse engineerable given the technology that we've got available to us nowadays to do that sort of thing. So yeah, trade secrets are inherently confidential in the heart of the business and shut away from external view, ideally. If you can, it would be great to be able to sort of distinguish between these different categories of technology and information within your business and handle them all separately. In practice, that's going to be really difficult. Things evolve over time, and they might only become, have a sufficient value after a particular amount of time or development, and then they qualify as a trade secret or whatever it might be. But the general thought of being able to have a tiered approach and have a set of processes or rules around handling information which falls into these different categories is something that you might want to consider. And obviously, there could be a lot more than 3 categories. You could have different grades or whatever within your tiered structure and different ways of handling different things for different purposes. But I'd certainly recommend that you do implement some sort of tiered structure if you can. So before we look at some sort of tips and tricks on the processes that you might be able to employ within your business to at these different levels, I'm just going to go through the law of confidential information. So typically I wouldn't go into the law in a talk like this because it's often not relevant and it is pretty dry as a subject. But with regards to this, it does give us some good indication in terms of the things that we should be doing within a business. There's some really good pointers within the legislation which says these are the things you need to do to make sure that you've got something protected properly, and it can sort of steer the behaviours that we're talking about. There are 2 types of law when it comes to, or 2 sort of distinct sets of law when it comes to confidential information. One is a common law right, so it's been built up over the courts, through the courts over a couple of hundred years or more now, where there's no sort of act per se, there's no statute, so there's not a confidential information act like there is a Patent Act or a Trademarks Act, but it's just law that's reasonably well understood, reasonably well defined, but it's done through the decisions of the court rather than by a statute of government. And then, so that's the first type, is the common law right. And then there is also a Trade Secrets Act, which came out of an EU directive in 2016. And that gives us a bit more of a codified approach and a sort of 3-point test that we can look at in the case of a trade secret. The 2 areas of law do overlap very much, and actually the UK position probably hasn't changed that much for the EU directive coming out. It was more to provide harmony across the EU when it did come out, but nonetheless there are some interesting pointers there. So we'll have a look at that in a second. So confidential information, generally speaking, could be any type of information. It doesn't matter really what it is or how it's sort of captured. The format is, as I've said there, generally immaterial, but it must be identifiable in sufficient detail. So I did have a client 2 or 3 years ago who an ex-director, a director, left with a load of test data, and he went off to start his own company with the test data, and he was restricted from operating for a certain period of time, but then when he could, he suddenly, as soon as he was allowed to act on his own, he launched a competitor product. It was slightly different to my client's product, and it would look like a purposeful attempt to get around the patents that they've got in place. But they were absolutely certain that the thing that had allowed this guy to sort of springboard into the market the way that he did was on the back of the test data, which my client had paid for. It cost several £100,000 to pay for this test data with regards to getting to certification. And then this other chap had taken it, the director, and used that to launch his business sooner. So it's quite a complicated case. But the point is, and the thing for this talk is that the business hadn't captured the information in a sufficient amount of detail that they could say that this chap has taken this information, he's used it for this purpose. We know how he took it and when he took it, because they hadn't got the processes in place within the business. So in that instance, we didn't go to court on that point, but the thought was from sort of counsel was that we wouldn't have enough evidence there to support a confidence action because the data wasn't captured in insufficient amount of detail. So that's a really important point. I mean, obviously having things in people's heads isn't great from a business continuity point of view, but also from an intellectual property point of view, and establishing something as confidential information, we really need to be able to have a physical representation of that information, and something we can refer to, and then also say this is what was taken and when it was taken. So having systems in place that allow us to do that is all for the good. So the second point there is that the recipient owes the disclosing party an obligation to keep the information confidential. So the person receiving the information must know that it's confidential and that they have a duty not to disclose it or use that information outside of agreed limits. That can be contractual, so you're probably all familiar with non-disclosure agreements, NDAs, or other contractual provisions where you have confidentiality in there. It could be a professional, so patent attorney client type of confidentiality understanding, or patient doctor understanding, or it could be implied. So implied confidentiality would be employer-employee is a good one. So if an employer gives information to an employee, there is an implied understanding that would be in confidence. Or it could be in the nature of the exchange and the relationship between the two clients, the two parties exchanging information, and the circumstances surrounding it. That's a little bit hard to put in context, and it would be a bit, I suppose, dangerous of me to put it in context. Ideally, if you're exchanging information with a third party, it needs to be a written agreement. You all work for big commercial organisations or commercial organisations, and so there's not really any reason not to have something in writing, signed, and that signed document be retrievable if needed later on. And then finally, the third point there is that there must have been a breach of that duty of confidence, and that has caused some damage. So this is a distinction over trade secrets, which I'll come on to in a bit more detail on the next slide. But there has to be, just taking the information isn't enough. Somebody must have used that information in a way that was detrimental to the disclosing party. So trade secrets, I say there's this separate sort of Trade Secrets Act, as it were, and that makes three distinct points. One is that the trade secret can't generally be known, which stands to reason, otherwise it wouldn't be a secret. It has commercial value because it's secret, so that's something to bear in mind for later on. And necessary steps have been taken to keep the trade secret secret. So this is about creating an environment within your company which allows you to keep something secret. There's not been that much case law on this at the moment, so there's not that much guidance as to what each of these terms means in practice, but it's probably going to be the last one, the steps to keep things secret, which is going to be the key to a good trade secret action and being able to enforce that against somebody. As I mentioned on the other slide, it's notable that there's no requirement here to show that there's been any detriment. You just need to show that the trade secret has been taken without permission. So you don't have to show any detriment to the company. So if, for example, an employee, former employee, took a trade secret as they were walking out the door, you could act reasonably quickly to stop them using that and get an injunction against them before they actually use it, which is why trade secret law is quite a powerful tool. So we know what confidential information is from a legal point of view, in a roundabout sort of way, similar for trade secrets now. So it's how do we turn that information that we've got into something that we can use within the business to allow us to not only be able to be in a position to launch a lawsuit if we want to, if we need to, but also how do we control it just to dissuade people from taking intellectual property either on purpose or in ignorance, I suppose, or through a lack of education. Most of the situations that I've seen over the years have come about because of mishandling of information rather than a sort of malicious intent or somebody trying to undermine a company. That does happen. There are quite a few cases that I've come across where people have been actually trying to take data and use it for their own goods or to sell it or whatever it might be, you know, proper cloak and dagger type stuff. But the majority of it is somebody will get hold of some intellectual property, some information within a business, don't really understand that there's any restrictions or requirements around this intellectual property, or they don't understand its value. They have a job to do, so they'll just take whatever they've got, do their job, and then you know, in ignorance of what could happen. So when we're controlling IP internally, it is partly so that we can launch a lawsuit later on if we need to, but it's probably the majority of it is actually creating an environment, an atmosphere within a business where we're discouraging people or trying to encourage behaviours which are more healthy for the IP. And it doesn't have to be difficult. It doesn't have to be onerous for people. They can still do their jobs. There's loads of fluidity there, but it just raises stuff in their mind and hopefully keeps it a little bit more at the front of the mind so that they're a bit more conscious when they're handling stuff within a business. So the basic message is really, and it is control. So if you can talk about IP control of information, you're going in the right direction. This is what it is. It's just the control of information. How can we do that? Restrictive barriers is probably the most prominent weapon we've got to do this, or means to do it. Restricted barriers can come in all shapes and forms. The most obvious one is physical. So if you've got door access or separate buildings or whatever it might be, floors on a building or however you can do it, that's obviously not an option that's open to a lot of clients if they don't have the premises or the funds to be able to petition things off like that. I have advised a client in the past, so they had mixed projects going on within an open environment, open office. And they wanted to segregate these. It wasn't hugely sensitive, but they wanted to create the impression of segregation of these different projects. And we advised there that they colour coordinated the space. So they actually got different coloured carpets in each area. All the lanyards and the security badges were colour coordinated to coincide with those areas. And then you could only go in your coloured area. So that is, you know, it's not very robust, but it is a way of flagging it with people and keeping it in their mind. And then perhaps, you know, when they go for lunch and they're talking with their colleagues, they, you know, different coloured badge, I won't talk about this, won't talk about that. And it helps lock it into place in their mind that what they're dealing with is sensitive information, and it's not for general disclosure. And that almost subconscious message is all you need a lot of the time. IT obviously is another easy way and quite ubiquitous now on IT systems, that, you know, you've got restricted access to folders or drives or directories. You've got password protection, encryption of documents. You've got document marking, which I'll mention a bit more in a second. You can also, I've worked for organisations before that ban electronic devices in certain areas. So you can't take your phone in, so you can't record anything or take any images. That's pretty hardcore to insist that people don't have their own electronic devices, but it is an option. It's one that some people do. You can ban memory sticks, for example. So the memory stick is just the easiest way to steal information ever. and very hard to track. So banning memory sticks, or at least having IT systems there that can detect memory sticks and track the information that goes onto them is another one you might consider implementing. And then contractual. So here we're talking about internal contracts, so internal measures, sorry. With regards to contracts, it's not NDAs and that sort of thing, and it's not necessarily intergroup contracts. If you work in a group, it is contracts of employment. So the UK is reasonably well set up so that contracts of employment cover implied duties of confidence, as we said on one of the earlier slides. In terms of IP ownership, then if an employee generates some IP or an invention in particular, that would be the property of the employer. But we can underpin those default positions with contractual wording. So contracts of employment can include, points on confidentiality and ownership of IP and duties under that sort of thing. And again, it just flags it in somebody's mind if you have that in your contracts of employment, just brings it to the fore a little bit and makes them a bit more conscious about it. And it also means that when they leave, you can point to their contracts of employment and remind them that there are these different points within the contract with regards to certain types of confidential information. You can also, if you wanted to, if they're working on a particular project, send them some not necessarily contractual information, but or a contract. It's more a note to say that this is what you're working on, this is confidential, etc., etc. Recordal of information. So we said earlier that it's really good to get everything written down and get it in a place where you know where it is, so you can point to it and say, this is the confidential information, this is the trade secret, and mark it up appropriately, keep it in the right place. It's also possibly worth, particularly with trade secrets, recording who has access to that information, when they accessed it, why they accessed it, and keep a sort of recordal of that type of information. So you can keep track and keep tabs of the more sensitive information within a business. Okay, document marking. So a lot of companies have document marking. That's something that is used reasonably commonly. If you don't have document marking within your organization, then there's nothing to stop you using your own informal system. So marking things as confidential or private or strictly private, strictly confidential, and having sort of an agreed set of words with meaning with those. You can use watermarks across the back of a document. You could say it's part of a project, and not to be disclosed outside of a project, or whatever it might be. And again, it's this message of this is the intellectual property here. We're dealing with something special. Just be careful with how you handle it and stop the sort of any sort of accidental leaking of information, that sort of thing. Education, that could be obviously formal training, a bit like this, or it could be we put in a system for a client where they were in an open innovation environment, so using a lot of third parties to develop technology, that sort of thing. Each of those had agreements in place, defining the ownership and the use of the IP that was coming out of those, and the use of confidential information, background IP, all that good stuff. But they're quite chunky documents, and the people working on the ground within those projects probably wouldn't have referred to the agreements, and if they had, were at risk of misinterpreting them potentially. So we created a system where following the signing of an agreement, we could look at it and provide a cheat sheet, basically simplify it down, and then there's just a single page of A4. These are what you can do, these are what you can't do, this is where the information's kept, this is when it needs to be destroyed, this is who's got access or can access the information, that sort of thing, and just make it a bit easy for people to understand, and to enable them to act within the confines of an agreement, or whatever it might be, whatever restrictions you want to put around a project. So that education point really is, and I suppose pointed education is really quite key to this undertone of raising people's awareness and changing their behaviours. I'll put risk assessment at the bottom there. So you could do a risk assessment. So if you had a project or a piece of information, then you could look at that on a time-to-time basis from time to time, and work out where it could potentially break down. Where's the information likely to leave the organisation or be mishandled? And that is up to you. I think that would probably come part and parcel with any processes that you were putting in place, but it is something that you could consider as a thing to do every 6 months, every 12 months, that type of thing, and just try and really tighten down on behaviours within a business. Okay, so I said trade. So the previous slide is trade secrets and its confidential information. So you can pick and choose out of those as you want to do, depending on the level of sensitivity. Trade secrets, because specifically we need to show that we've taken steps to keep the trade secret within the organisation, not just externally, but within the organisation itself, then I think it's sensible to have a register of trade secrets and to make sure that the restrictions and stuff around a trade secret are as tight as they can be within an organisation in terms of the physical barriers and the IT and all that sort of stuff. But also keeping a register of trade secrets is very useful. Again, it focuses the mind. It allows you to identify where they are, what they are very quickly. So, for example, if you wanted, if Mr. Unscrupulous employee walked off with a load of data, you could go to your register of trade secrets and hit the points that you need to hit. This is what it was. This is where it was. This is when it was taken. This is the value. And you can launch your lawsuit very quickly and get an injunction before they can do anything with it, for example. So what would you keep in a register of trade secrets? The most important thing would be, or to emphasize, is that it has to be metadata. It can't be, a collection of the trade secrets, because then you'd have such a restriction over that location that it wouldn't be workable. So it's, when I say metadata, it's data about the trade secrets. So it is the location, recordal of users, who's got access, is that up to date? When did they access it? How did they access it? Why did they access it? That sort of thing. Record of that information. Value. So we said earlier on that a trade secret has to have commercial value because it's secret. So it's not necessarily the value in a monetary sense. If you could do that, that would be great. But that's obviously quite a hard thing to do, and probably changes reasonably regularly. But if you capture the project that it was involved with, or the sort of commercial products or whatever it might be, the value stream that's attached to it, then that's good information to capture there. And then again, audit risk information. That's probably more worthwhile doing on trade secrets, just to make sure that you're tight on it. And it's again, it's not just about the sort of lawsuit aspect of it. It is about making sure that you have got control over the trade secrets and that you don't let things wane and fall to the side, because that's when the information is likely to be misused or either maliciously or innocently. But keeping it nice and tight and locked down as you need to do. Okay, I'm conscious that I can't ask for questions, obviously. If you do have questions, then please do put them in the chat function, and we'll get back to you later on. So I've just noticed the time as well, so I'm way over half an hour, and I've got another sort of 10 minutes to do. So if you do need to bow out now, do so, and we'll send you the recording afterwards, obviously. Sharing of information externally. So no business operates in a vacuum. You do all have to interface with the outside world, be it customers, clients, investors, collaborators, partners, that sort of thing. There has to be an outflow of information from your business for you to operate. So that's acknowledged. It is part and parcel. The disclosure of information can be in any way, shape or form. Once it's gone out of the door, it's gone. Excuse me. So it could be, emails, conversations, internet marketing, advertising, that sort of thing. It doesn't really matter. Once confidential information is in the public, it can't be considered as confidential information anymore. It wouldn't have a quality of confidence. So go on technical publications. I've put there some companies like to do that and have processes in place for vetting those before they go out of the door. Patent protection. Obviously, if you're filing a patent application, that will get published after 18 months, if not sooner. And so there needs to be an informed decision as to whether to file a patent application and have it published, or to keep it as a trade secret internally, and have it for your own use. We'll talk more about that in the second part of this talk, which is in a couple of months' time, when we talk about the registered rights and that sort of thing. And then obviously sharing of information externally, human error, putting the wrong email address on somebody's, when you're sending an email out, for example, is quite a common one. I'm conscious of time. I've got a great story about that, but I've not time to share it. And then, like I say, ignorance or malicious intent. So there's lots of ways that information can leave the business. When you share information consciously, I think it's really important to do it on a need-to-know basis only, and so it sounds obvious, but only to the parties that need to know, rather than just putting out blanket information, so that you minimise the number of points that information then can be bounced on and leaked out to other people, and then minimise the information shared and received. So this is really to do with if you're working in a collaborative environment, or you're approaching companies under an NDA, and you want to find information from that company. I will come on to that in a bit more detail on the next slide when we talk more about NDAs. But yeah, minimise the information, keep it very tight, and you share what you absolutely have to. The most important thing probably when you're sharing information is to have a written agreement in place, as I already said, be that a non-disclosure agreement or some other sort of contractual arrangement where confidentiality is expressly addressed, and obviously having that signed and stored in a safe place is an essential part of that. Having an agreement that's not signed, or that you can't find the signed copy, is not worth the paper that's it's written on. Document sharing system. So again, a lot of companies have these sorts of things where you monitor and record information going in and out. So the typical things you'd have in something like that is who was it sent to, why was it sent, when was it sent, how was it sent, the agreements in place. So there's a question of have the agreements been put in place, but also what agreement was it. So if you're sending information out, it would be entirely reasonable, I think, to put on the email, so that you're sending out that this information is provided under such and such an agreement, these provisions apply, or whatever it might be. And again, it's this behavioural point that you're just flagging with people, the recipients of that information, that this is it's subject to some confidentiality. It needs to be treated properly. Please make sure you do that. And I said, just raising awareness. Having a document sharing system also gives us something to point at if we ever do need to sue somebody, or bring an action. Then it gives you something to point at, to say, this is the information, this is when it was shared, this is how they've used it, how they shouldn't have used it. Yeah, all good stuff to keep recorded, and again, can be done reasonably minimally. I don't think there's huge amounts of, well, depending on the system that you've got, it should be reasonably straightforward to be able to implement something like that. So sharing of information under NDAs, this is with regards to having confidential information and sharing it, but keeping it in confidence. The NDA is the primary tool of use. So NDA, non-disclosure agreement, so that if you share something under an NDA, then the receiving party is under this obligation to keep that information in confidence. The issue with NDAs is they're very difficult to police, in terms of once you've given that information over, you don't know what the receiving party is going to do with it, and you're relying very much on their good intentions, good faith, to handle that information properly. So that brings us back to the point of make sure you minimise the information that you're sending across. So NDAs only protect the sharing of information. They don't protect the creation of IP or anything else in terms of ownership or use, except for the restriction on use. So, for example, if you have an engineer, they're going to a meeting to just try and source a new type of technology, then if you get your NDA, that's great. You can go ahead and get the information that you need. what I would advise against is going to into that conversation and saying, we've got this problem, how can you solve it? Because then that would get the person that you've gone to start thinking, and you're straight into the territory of creating IP. The problem is that an NDA doesn't cover the creation of IP, and the ownership of that IP created would rest with the party that came up with it within that environment. So it could be jointly owned IP because you both sat in the room together, or it could be the person that you're talking to. You can backtrack and try and close that off later on. So let's say that they've got a great solution, you want to own it, you want to protect it, you want to use it, then you can have an agreement in there with them around that piece of IP. But what if you don't stick with that party? What if you go to a different party? What if they're not quite right? Great idea, but not quite right. We're going to work with these guys. Then you don't really have any right to this information that was created. So I would strongly advise that you don't get into that sort of situation where you're over talking something. The better question to ask is, what can you do? Not how can you solve our problems, what can you do? And then that just allows them to give you the information that you need. Then you can go away and think about it, and use it to your own ends, and then engage with them more fully for a discussion on the creation of IP or the solution of problems later on. NDA, so generally should be project specific. So having an NDA that covers all information shared between two companies isn't ideal, because it makes it more difficult to be explicit about what information has been misused, and why there was an obligation of confidence. So I would advise generally that the scope of an NDA should be quite narrow. Again, record the information that's shared. So similar as we just said, that sort of document sharing system, make sure that you know what's sent, when it's sent. And then let's follow up with it with the termination of an agreement. This is something I've seen only a few times, and I find it really impressive, where a client has received an email from somebody saying, we've noticed that we've come to the end of this NDA agreement. Under the provisions of that agreement, we have now returning the information to you, and we've deleted all copies. And that really does give the impression that that person that had that information knows what they're doing, they're on top of their IP policy, and are very respectful of your IP. And that, for this client, was, wow, great, yeah, we'll work with these guys again. So it could be that, you get to the end of the agreement and you proactively say that you're keeping in step with the agreement and the provisions there, or it could be the reverse, where you actually note that you get to the end of something, that the term of the NDA or whatever it might be, and actually ask for the return of the information, or the information to be destroyed. Whether that's worth your while or not is another question, because obviously that does take an amount of resource to be on top of the NDAs and all that sort of stuff, and to issue the email, and what if they don't come back or don't confirm that they've done it. But it does create a good impression, I think, in my mind, for being tight on intellectual property. So finally then, handling of other people's IP. So as I said earlier, all businesses, or a lot of businesses, deal with IP from other firms, other companies, third parties. So it could be drawings or data or whatever it might be, but whatever comes into the business. And handling that properly, I think, is really important. It will likely be provided for a purpose, obviously. It will possibly be provided under an agreement, and just keeping on top of those, being aware of what's coming in, making sure people are educated again, the recipients of that information, how should they handle it, who can have access to it. It's very easy for I will give another example again. I'm conscious of time, but I worked for a company once where they had a part made, and they needed to interface another part onto the part that had been made. They had the drawings for this part that had been made from a third party, the people that got to make the part for them. But in order to get the interfacing part, they wanted to send out these drawings and put it out for a tender process. So the guy that was in charge of this took the logo of the third party off the drawings, put their own logo on there, sent it out for the tender process. That ended up getting back to the originators of the drawing, who were really not very impressed at all. They thought they were being cut out of the loop. They thought that the tender process was to have this part made that they'd been contractually put in place to make, and it got very heated very quickly, and really damaged that relationship. So the guy who took the logo off the drawings. I don't think he knew that that was bad. He thought, you know, they're going out in our name, we own them because we paid for them, which wasn't the case in terms of the copyright of the drawings. Yeah, there's quite a lot going on there, but it was just a lack of awareness from that person. So in total ignorance, presumably. But yeah, really had quite devastating consequences. And that when we divested that company, that came to the fore then, because there was quite a bit of history on there in the files and stuff, which caused something we smoothed over and it was fine, but yeah, caused some issue. So again, this education point, making sure people are aware, recording what's coming in, and handling it properly is quite important. And it's really, you know, the implementation of that is similar to what we've already described for other things. It's just that different angle of the fact that you've got stuff coming into the business. What I will say there is if you do ever find yourself in a situation where you have or somebody in your organisation has done something wrong in ignorance or otherwise, is to own up to it as quickly as you can, generally. And that's my own personal opinion. I'm not saying that's professional advice, but when I've seen that done in the past, I think closing it down very quickly, limiting any sort of further divulgence of confidential information. So let's say you put the email address incorrectly on an email, write to the recipient, whoever that is, straight away and say, look, I've sent you this in error, very sorry, please destroy it. It's confidential information, do not send any further. And then at least that way you can say that they're under an obligation of confidence from that point, and hopefully sort of limit down any damage. If you just ignore it, then there's a risk that it could get worse as time goes on. So there we go. Right. So handling of this IP. So that's going back to the example I just gave. Could be financial compensation. So there could be things within an agreement which explicitly says if you leak our confidential information, you will owe so much in terms of financial compensation, or it could just be the damage that comes out of that. Damage to the working relationship, sure. You know, if you mishandle somebody else's IP, they're going to be pretty miffed about it, might not want to work with you again. Loss of reputation speaks for itself. Mutual respect. So normally, or quite often when you're exchanging IP, it's a two-way process. If you're getting IP and it's not properly looked after within your business, then why should they look after your IP on the other side? So yeah, it's a two-way street often. So there we go. Right, that does me. So hopefully that was useful. So if you've got questions, then do please let us know. It's quite high level. So if you want to sort of delve down into any of those concepts or get a bit more information, or you want us to look at your business and provide some advice, I won't speak for other members of the practice, but I'll certainly gladly sort of sit in with people and give them some time free of charge to do that. And I imagine other partners would as well. But yeah, that's where we're going. So hopefully, I said that was useful. So the second part will be in a couple of months. That will be more to do with registered rights and that sort of thing. So hopefully see you then.